Hey gang, Stephen Marshall, KYLandlordlaw.com, back with another update. Nothing groundbreaking, but 4 agenda items today. We're going to talk about the new eviction court procedures that took place this past Monday under the new Kentucky Supreme Court order. We're going to talk about how the judges are actually handling these signed CDC Declaration Forms. Then I'm going to cover some frequently asked questions that I've been getting from several of you guys. And then finally, we're going to talk about a new lawsuit challenging the CDC regulation. So that's what's on our agenda today. But we're going to start out with our new eviction court procedures because earlier this month, the Kentucky Supreme Court issued a new order stating that on September 21st, there would be a new process for non-payment eviction cases. So the way that's actually going down is that on the first court appearance, if your tenant doesn't show up, you're going to be granted a judgment just like normal. Okay, you may need to give testimony or whatever, but the judge will grant a judgment as usual. However, if your tenant appears, the process is going to change from what you're used to. The judge is going to advise both parties, both the landlord and the tenant, of local and state rental assistance options. One of those is the Healthy at Home Eviction Relief Fund, but there are also some local options. And the judge is also going to advise the tenant of the CDC Declaration Form, and then the matter is going to be scheduled for 2 weeks down the road. Okay, that's in all cases. Now, if the tenant signs the CDC Declaration Form at any point, right now those cases are being bumped to January. Okay, the courts are considering those tenants protected and is bumping the case until January, which raises the question that I'm getting from you guys. What do you do if you believe your tenant has falsely signed the form? And we don't have great options right now, because if the tenant signs the form, most judges, now not all judges, but most judges are not willing to make a finding right now on whether the tenant qualifies for protection under the CDC regulation. They're not willing to hear testimony on whether the tenant has actually been using best efforts to obtain rental assistance, whether they've lost household income due to COVID, or if they've been using their best efforts to make timely partial payments. The position of most of the judges in Central Kentucky is that the landlord's remedy is to file a criminal complaint with the U.S. Attorney's Office alleging that the tenant has committed perjury. Now, that's not a great option because it's highly unlikely that the U.S. Attorney is going to prosecute those types of cases. I hope that I'm wrong, and if you have a case where the tenant's falsified their form, I hope that you'll file it. Okay, I hope you'll file a criminal complaint. But I just suspect that the U.S. Attorney's Office has bigger fish to fry than a perjury charge against a tenant. So, the only other option, if your judge will not hold a hearing on whether the tenant actually qualifies under the form, is to ask the local circuit court to make a determination on whether the eviction court should have a hearing on that issue. Now, that option is going to take some additional time and some additional expense. So you're going to have to decide whether you want to go after that option or not. But I think that's probably the only option if the judge in your case will not look into whether the tenant is telling the truth on the form. And so far, most of the judges are not looking into that issue. Okay? So, third agenda item, frequently asked questions. If my tenant signs the CDC form, should I accept their partial payments? Part of what they're declaring when they sign the form is that they're using their best efforts to make timely partial payments that are as close to the full payment as their circumstances allow. So theoretically, they're going to come to you with some partial payment, okay, as close to the full payment as possible. Accepting that money is going to likely cause your January case to get dismissed. So if you choose to accept it, you'd need to give a new notice to pay or vacate and then potentially refile your eviction case. I've written a number of posts on the rules of partial payment, so make sure that you go to the blog post that accompanies this video and review those posts so that you're familiar with the partial payment rules. And so ultimately what you've got to decide is if the money that's being offered from your tenant is enough to give up your place in the January eviction line, because your current case is being rescheduled for a January docket. And if you accept the partial payment, that case will probably have to be dismissed and you'll have to refile, and you may not get in front of the court until February or perhaps even later. So you've got to decide if the money that the tenant is offering you right now is worth that. And that'll be different in each case. Question number 2, am I required to participate in the Healthy at Home Eviction Relief Fund process? No. I know that some judges mistakenly may have told you you have to participate in that process. That's only true if you want to get the money. Okay? If you're not required to participate in the process, it's just that you will not be eligible to receive rental assistance from the Eviction Relief Fund if you do not participate in that process. So if you want to receive the assistance, get your tenant to fill out an application. You'll get notified when they do, and you fill out an application, and then ultimately both of you have to sign an eviction diversion settlement agreement. But in answer to the question, you're not required to participate. Now, if your tenant signs the CDC form, I think it's wise to participate in that rental assistance process, but you're not required to. You can choose to keep your place in line and keep your January eviction court date as scheduled. Make sure that you understand the difference between the Eviction Relief Fund and the CDC form. On the CDC form, you are not required to participate in that. You don't have to sign it. There's nothing you need to do except receive the form from your tenant. On the Eviction Relief Fund, in order to get rental assistance, you are required to participate in that process. Okay, it's an online process. So make sure you understand the difference between those two. The CDC form, you don't participate. The tenant just reviews it, and if they sign it, they give it to you. On the Eviction Relief Fund, you do have to fill out an application and sign a settlement agreement if you want the money. And then last question, can I still evict for lease violations and non-renewals of leases? Yes, those cases are still allowed to move forward as usual. The usual notice and the usual process in the court appearance. In lease violation cases, you're going to want to make sure that you gave the proper notice that specifies the behavior that violated the lease in as much detail as possible. Where I see people going wrong is just issuing a notice that has a general statement on it like noise violations or harassment instead of specifying the who, what, when, where, and how. That sometimes get notices to be deemed by courts as being insufficient and your case gets dismissed. So on your notices, be very specific on the behavior that violated the lease, and be very specific on the time frame the tenant has to cure the violation, and then finally be very specific on the consequence for the tenant if they fail to cure the violation. On non-renewals, make sure you have a legitimate business reason for the non-renewal, and also make sure you don't hold your tenant to a higher standard than other tenants who are similarly situated. The problems you run into on non-renewals are retaliation claims and discrimination claims. You can avoid the retaliation claim by having a legitimate business reason for the non-renewal, and you avoid the discrimination claim by not holding your tenant to a higher standard than other tenants who are similarly situated. But if you follow those steps, then lease violation evictions and non-renewal evictions are moving forward as usual. And then on September 18th, the National Apartment Association joined a lawsuit challenging the CDC regulation. They have asked a federal court in Georgia to halt enforcement of the regulation and declare it in violation of the U.S. Constitution. In the post accompanying this video, I'll have a link where you can read more about it, but I hope to be able to report at some point in the next month or two that a federal court has declared the CDC regulation unconstitutional, and it will allow evictions for non-payment of rent to move forward regardless of whether the tenant has signed the form or not. And then the last thing I wanted to talk about, educational opportunities. I've had to cancel most of my in-person landlord education conference trainings this year, but I'm thinking about offering them in webinar form. If that's something you'd be interested in, please let me know in the comments, whether it's on social media or on YouTube. Just put in the comments, interested. And obviously I'm not asking for a commitment at this point. I'm just trying to gauge interest, so I'll know whether to put one of those on, because I know people are trying to get their training hours in, trying to learn more about the process, trying to protect their rental investment. So I want to get that done. I just want to make sure it's going to be a worthwhile investment for all of us. So that's it for today. If you need legal advice, shoot me an email, smarshall@trippleslaw.com. Otherwise, have a fantastic rest of your week.